Lordship, could it be listed in the next week? That's my humble request.
Case be listed immediately after filing application.
Highly obliged.
My lord, in this matter, my lord, the P1 is order of termination, my lord.
Yes.
That termination says, my lord, the P1 is says, my lord, विषय अंतर्गत देख है कि इस निकाय में आपकी सेवाओं की आवश्यकता ना होने के कारण आज दिनांक से आपकी सेवाएं समाप्त की जाती हैं.
Yes.
Prior to this, my lord, earlier I was terminated. I raised the industrial dispute,
Yes.
and the labor court
What
is,
was your nature of employment?
my lord, daily wager.
You were daily wage.
Yes, my lord.
Yes.
My proposal for regularization is, my lord, recommended to the government, my lord.
Yes.
My lord, what I want to say that, my lord, earlier I was terminated in 2010. I
Yes.
raised the industrial dispute. The labor court has said that, my lord, the termination is illegal and directed for reinstatement, my
Yes.
lord. The order of labor court is under challenge, my lord. They refused to comply with the compliance of the 17B. I insisted before the court, my lord. The court has given the direction, that is annexure P5. That court has given direction to join the services of the petitioner, my lord. They always create the hurdle to
Yes.
take back me in service. After joining, my lord, they again terminated my service. That is P6, my lord.
P6.
P6.
Yes.
P5 is, my lord, that this honorable court has given direction to join me. And, my lord, the P6 is saying, my lord, I am not joining the duty. And because of that reason, my lord, my service was terminated in the year of 2019. That P6 is the order.
Yes.
I challenge that before this honorable court, my lord.
Yes.
In this honorable court, my lord, the court has found that, my lord, I have worked. Their reason given in the termination, that is bad. And accordingly, my lord, directed for reinstatement, my lord.
Yes. Order
That-
was set aside.
Yes, my lord.
Yes.
Again, my lord, they terminated my service. That is under challenge, my lord. And they stand in reply, my lord. They are saying that, my lord, I am not joining, I am not in the employment since 2023. But the termination does not reflect that, my lord. Kindly see the, my lord, the reply. Para 6, my lord, that is my status they have given. And the para 9 of the reply. The para 9 of the reply says, my lord, the para 9 says, my lord, the perusal of the order of termination dated so and so. This honorable court will find that the termination is simpliciter, and no stigma was attached and nor passed in consequences of disciplinary proceeding. Thus, this termination is amount to retrenchment within the meaning of 200 of the Industrial Dispute Act.
Yes.
And further, they say, my lord, they have not completed 240 days, therefore the 25F is not required to be complied with. Lord, and they filed this.
So why you are not satisfied with a lump sum compensation?
My lord, the difficulty is this, my lord, my proposal is pending to the, my lord, the government for regularization, my lord. They wanted to frustrate this object, my lord. And, my lord, my lord, if kindly come to the, my lord, the annexure R1 and R2 filed by the respondent, my lord. R2 is at page 79.
Since you are a daily wager, no service rules are applicable to you.
My lord,
If there is no work,
the-
they can terminate.
my lord, they can terminate, my lord,
Yes.
but they do not have any, but they after compliance of the, my lord, the procedure. Without following the procedure, my lord, they cannot. My lord, here, my lord, the matter is pending before this honorable court. This honorable court has given the specific direction to join the petitioner in service.
Their petition is pending.
That, my lord, the order of labor court, they challenge it, that is pending, my lord. My
That is
submit.
pending.
Yes, my lord.
So before passing that order, you ought to have taken leave of the court.
That
But
is the object, my lord. And
Court
even
is seized with the matter in the petition, therefore you could not have passed the order without leave.
मतलब there is no need as the मतलब section 200 देखेंगे आप ID Act का
Not 200.
जी
You have challenged the order of labor court regarding his reinstatement.
yes
That is pending before court. Court is seized with the matter. How you can pass an order?
but the question is मतलब he is absent from duty from 1st February 23 to 18 to
Nothing
26
is mentioned in that order.
so
Impugn order में तो कुछ
so
mentioned नहीं है.
मतलब तो I am not terminated his services on the ground of absence मतलब
you
therefore
take-
मतलब
Take leave of the court in that petition that you want to terminate his service. And as work is not required.
the order of
Well,
labor
it was
court
a
has to be
provision.
modified.
Yes.
If they wanted that, and the compensation can be granted, court will find that, my lord. The termination will go, my lord. The earlier, my lord, this, they take a stand, my lord, I was not joining the services, I am continuously absent. The court, the division bench of this honorable court said that, my lord, that the ground which is taken in the termination, that is incorrect. Therefore, the court has interfered with the order, though that is without back wages, my lord. Again, they are saying that, my lord. In written, they cleverly passed the order of termination just to frustrate the proceeding of the this honorable court as well as the, my lord, my regularization proposal, my lord. That is very bad, my lord. This is the abuse of process.
Yes.
Yes. What is?
So I will quash this order. You seek leave in pending writ petition.
थोड़ा सा देख लेंगे मैडम ये 200
इसमें देखना क्या है? There is an order of labor court to reinstate him.
Yes.
You have reinstated.
yes madam
And you have simultaneously challenged the order of reinstatement. Then you terminate him without seeking leave of the court. Order of reinstatement is under examination by this court.
मतलब first termination that is the reason kindly see the reason for termination madam Alexa
This is third termination.
yes third Alexa madam P
You file your reply, I will consider.
The reply is there, my lord.
reply file किया
So what is your reply?
The reply they are saying, my lord,
reply वाला
the termination is simplicity.
Yes, yes.
termination in simplicity मतलब no stigma is attached as per section कार की आवश्यकता न होने के कारण आपको बाहर किया गया एब्सेंस का कोई उसमें जिक्र नहीं किया रीजन आवश्यकता नहीं आवश्यकता क्यों नहीं रिप्लाई के पैरा 1 and 2
Petitioner
में
has filed this petition under Article 226 of the Constitution of India challenging impugned order dated 19/2/26 contained in Annexure P1. Learned Counsel appearing for petitioner submitted that earlier services of petitioner was terminated without complying with Industrial Dispute Act 1947. Therefore, he had approached the court. Labor court has granted order of reinstatement to petitioner. Petitioner was reinstated in service. After his reinstatement, respondent has challenged the order by filing writ petition bearing number so and so. Said writ petition is pending consideration before this court. It is submitted that during pendency of said writ petition, respondent had terminated the services of petitioner by impugned order dated 19/2/26. It is submitted that impugned order is bad in law and is only filed to frustrate fruits of order passed by labor court to petitioner. Full stop. Order is malified and same ought to have been set aside. Counsel appearing for respondent submitted that order is passed simpliciter. No stigma is attached to the order. Work of petitioner was not required. Therefore, his services were ended. Full stop. Petitioner is a daily wager and therefore no compliance is to be made regarding notices or to follow notices. If there is no work, services can be terminated simpliciter. In view of same, no interference is called for in order dated 19/2/26 contained in Annexure P1. Heard the counsel for the parties on going through facts of the case, it is found that respondents had challenged the order of reinstatement of petitioner. If they will terminate the service of petitioner, orders passed by labor court and also petition which is pending before high court will become infructuous. Respondent could not do so. They ought to have taken leave of the court before passing of impugned order dated 19/2/26 since High Court is seized with the matter and examining the order of labor court regarding its validity. In view of same, impugned order contained in Annexure P1 is quashed.
P1 and P2, that is publication.
P1 and P2 is quashed. Respondents are at liberty to seek leave of the court in writ petition for passing the order.
I am great.
Disposed of.
Lordship, praying for withdrawal of this petition with certain file afresh with certain amendments.